So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. As Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had prelim back in April. It got bound upstairs. The transcript's probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well, it takes
trial in 180 days. I didn't have a prelim for 90 some days.
Okay. So you're waiting on your transcripts, correct?
Yeah.
So they come when they come. They have a time period that they're allowed to get those done by, and they're not going to be done till July. And so you really, your attorneys probably advised you that you don't want to proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times due to the prosecutor filing bad writs or however, I just would always.
Well, I can't argue the merits of that today because I got to wait for motions, and your attorney will file the motions.
So that means I can't have a trial in 180 days.
Buckle up, guys. Today we are diving straight into a courtroom where strict judges face off against defendants who are clearly out of their depth. From the very first second, you can feel the tension as the stage is set. Michigan's courtrooms, probation violations, and defendants who underestimate the system. This is where we get the initial context and stakes. Soft judges won't cut it today.
Today, Mr. McKenzie, because we're only here on the violation of probation. Your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted a separate hearing.
Once it's up, all right, I can set you a trial on this.
Yeah.
So, Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would say 2 weeks.
2 weeks. All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie?
Yes.
Okay.
Can he do that, Your Honor?
Yep. So, I mean, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Miss Adams, I'm looking for about an hour.
Yeah.
Who are you going to call as?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
And discuss that with him. Do you have some witnesses?
Yeah, her name's Tamia Dillard.
Tamia? Oh, she runs the program.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All right.
She does, and she was who I would be calling for a witness as well.
Okay. Okay. So.
Are you definitely going to call her, Ms. Teskey?
Yes.
So I would not have to subpoena her
No.
then? All right. You okay with that?
Yeah.
All right.
Ms. Anton, could I speak for a second?
No, I'm looking for a date. So you got to wait a minute.
All right, well. I don't know what the fuck to say.
I'm sorry. What'd you say?
I told him I know what to say. He can't be my lawyer. I can't do this with him.
Then you are more than welcome to hire an attorney, but.
I need somebody that's going to do something.
So, Mr. McKenzie, here's the deal. You ask for court-appointed attorney, you get a court-appointed
I got
attorney.
this back.
Listen to me.
Now
All
listen.
right, you are held in contempt,
Oh my
so
God, you think
I'll bring you back
I-
next week. Thank you.
Give me 2 years of contempt, please. Could you?
You're actually looking at 5 years.
Oh, please don't.
Oh,
Let's talk about
have a good
this, that
day.
bitch.
Oh, like that's the worst thing I've ever been called. I've been called by,
That's the worst thing you've ever done.
no.
Here, the judge breaks down exactly why Mr. McKenzie is in hot water. Failing the RAP program guarantees jail time regardless of his new charges. The tension is in the cold, hard truth of the law versus his expectation of leniency. Every word from the judge slices through the confusion, laying out the consequences and giving viewers a clear understanding of the legal stakes in a probation violation scenario.
July 3rd, is that correct?
Yes,
Those sunglasses, or are they prescription?
prescription.
Do you see the plea questionnaire waiver of rights form I have in front of me?
I see on this,
Did your attorney go over this document with you?
very briefly.
Well, maybe if you weren't 18 minutes late, you could add more time with your attorney, right?
I forgot my money. I had to turn around.
Maybe you should have been here maybe 20 minutes prior to your hearing to go over this with your attorney, correct?
Correct.
And Your Honor, I do have a copy of it in front of them as well.
Thank you. And the fact that you forgot the money, is it the court's problem?
A little bit, I mean, but.
Oh, I forgot it for you?
No, it's my problem, but it made it your problem.
It did make it
By
my problem. It made
postponing-
it the district attorney's
by
problem. It made it
postponing-
Mr. Keene's problem.
I apologize.
You are putting my calendar behind right away in the morning.
That's what why I said it is a little bit your problem.
No, it is my problem.
Yeah.
In this segment, we see the courtroom machinery in action, scheduling trials, determining necessary witnesses, and setting expectations. The judge carefully navigates defense requests while maintaining authority. The suspense builds as we realize the defendant's choices will directly influence how the trial unfolds. This part highlights how courtroom logistics themselves can heighten tension.
Document with you, correct?
I have to do stuff and I have a copy.
Yeah. Yep. So he's went over multiple times. You've had Mr. Keene for some time on this case, correct?
Mhm.
Yes?
Yes,
And you've had him for this time when you've been trying to complete the IDIP, correct?
and I have.
Okay. And so, Mr. Keene, this isn't the first time he's talked to you about what it means to plead guilty to an OWI third, correct?
Correct.
And he's went over with you what the state would have to prove, correct?
Yeah.
Correct?
Correct.
And he's went over the maximum penalties and the minimum penalties you could face. Is that correct?
Yeah,
And he's went over the offer with you that has been presented by Mr. Renicky to recommend to the court IDIP guidelines, correct? What the
Yeah.
offer is, correct? Because you know you're doing an IDIP program for benefits, right?
There was a little confusion between my IDIP worker and him about the hours for community
I don't
service.
care about the community service
Okay,
hours.
I'm just saying that
The other stuff, right?
the other stuff, yes.
Okay. And so he's went over certain other things with you, right? Such as your constitutional rights. Did he go over that with you?
Yes,
And did he go over the fact that I don't have to accept the IDIP guidelines if I thought that the facts of the case warranted it, or your history, et cetera? Did he go over that with you?
yes, ma'am.
Okay. So it sounds like he did go over all of the information on this plea questionnaire. Is that your signature on the second page?
Yes,
So you are 44 years old. You can read, write, you understand the English language. You have not had any drugs, alcohol, or other medications, and you have not been deemed mentally incompetent, correct?
correct.
So do you understand all of those constitutional rights on that document that's sitting there right in front of you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights? You won't be able to have those rights again. You can't plead guilty and say, you know what, Judge, I changed my mind. I want a jury trial. You know, do you understand that?
Yes,
And so by pleading guilty, those rights are going away. You understand that?
yes,
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I don't allow coffee in here.
I'm sorry.
I only allow water.
Apologize.
Okay, so do you understand that by pleading guilty, you could be deported if you're not a citizen? I have to ask that
Yes,
to everybody. Okay. And do you understand that, again, here, the state would have to prove certain things, that on or around May 28th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. And this would be a third offense. Do you understand what the state would have to prove?
What would they have to prove?
You operated a motor vehicle,
Okay,
you
yeah,
drove, you operated, you
Yeah.
turned a key, you had the keys
Okay.
in the ignition, you did something to operate the motor vehicle.
Okay,
And that you were under the influence of an intoxicant. You understand that?
Okay.
Okay. Do you understand they would have to prove that?
mhm,
Okay. And this is your third offense, third conviction? Right? Is that a yes?
yes,
Okay. And do you understand that upon conviction, you face a fine of not more than $2,000, that excludes court costs and fees, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
yes,
Plus that the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA, OWI assessment and driver safety plan and follow through. You understand that? Yes?
yes.
And you should have done that with the IDIP program, so that should be,
It's taken
Covered.
care of.
yes. All right. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes,
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
yes.
Do you have any questions for your attorney or the court before we proceed?
All right.
And that's all kinds of fun today.
Damn it.
The judge addresses Mr. McKenzie's behavior head on, warning him about contempt and the seriousness of hiring an attorney. The suspense comes from watching the defendant navigate the limits of courtroom decorum. His flippancy and disbelief collide with the judge's strict enforcement, offering viewers a lesson on the high stakes of courtroom misbehavior. Part 5. Switching scenes. We meet another defendant facing DUI charges. The suspense is immediate as the judge scrutinizes him on missed deadlines, legal procedures, and understanding plea documents. The tension lies in the defendant's casual attitude conflicting with strict judicial expectations, reminding viewers that ignorance and tardiness can be extremely costly in court.
Evidentiary issues. You can object to evidence coming in because it violates a rule of evidence. This is not a violation that you're alleging. This is a dispute, and you'll have a chance to give your own testimony. I'm not granting an adjournment because we had our first hearing. We've written you here, meaning the government has paid for you to be here for today's court date. You were made aware of that at your last court date, which was back in November. This is now January that you would be having a hearing today. So you were to prepare yourself and have the court subpoena wherever you wanted to have subpoenaed here. You did not make those arrangements. Today's the date and time set to proceed with the hearing. So your objection is overruled. You can give that answer.
Can you please read the letter?
This is apartment 235. I ain't paying y'all shit. And if another thing comes up missing in my apartment, I am going to beat the maintenance dude until he tells me who's been in my apartment, and then beat the shit out of them, because I have a constitutional right to defend me and mine against any enemy, foreign or domestic. And then it's signed by Mr. Black.
And then page 3 of Exhibit 1 starts the lease violations.
Lease violations, yep, starting back in April. This one's April 3rd of 2023. You were seen by a staff member not having your dogs on a leash, not picking up feces. Please remember to always pick up after your dog and, have them on a leash.
So it starts on April 3rd, 2023, and the last one is July 11th, 2023, right?
Yes.
And at this time, can I have
Yes.
the second Exhibit 1 be introduced in the evidence, admitted into evidence?
Any objection to Exhibit 1?
Yes, because like I said, when I sat up there and asked the apartment complex to sit up there and do anything to stop their neighbor from banging on my wall, I've got police reports. I asked you guys for a
Okay,
continuance.
but I'm asking you about these specific.
Because I'm telling you why the specific, because they wouldn't stop the, next door neighbor from banging on my wall,
Okay.
slamming up stuff.
Thank you. The objection is overruled. The People's Exhibit 1, is it?
Yes.
That's admitted.
Have there been more lease violations after July of 2023?
Yes.
Can you please describe what else has happened?
Since July of 2023, we've been having a lot of quiet enjoyment issues, and quiet enjoyment violations coming in. Mr. Blocker's neighbor and him, there has been a lot of complaints against, Mr. Blocker as far as him making excessive amounts of noise, the door being kicked in. There's also a police report on file, where Mr. Blocker actually punched his way through his apartment to the neighboring apartment. And there are pictures that I don't know if I got you, Jeff, but where he actually busted through his apartment into his neighboring apartment.
When he kicked in the neighbor's door, do you know if this was on video?
Yes.
Can you please describe to the court how the video cameras work at South Washington?
There are 101 cameras throughout the entire property, and we have security that monitors them, and they were called for the incident, reviewed it, and then sent us the video footage.
So this is the point where you guys get to watch this beacon of neighborly love express his affection towards his neighbor with the bottom of his shoe.
Sorry, still showing it. Now, Ms. Mercenti, can you please explain what happened in that scene?
Mr. Blocker was in front of 237's door kicking it, and then he walked back into his apartment.
And right here, he's kicking, is that his neighbor's door?
Yes, unit 237.
And then at some point, does he kick that open?
On that evening, no, he does not kick it open.
So was this one of the lease violations for Mr. Blocker?
It was.
And I'm gonna stop sharing. And after that incident, where he was kicking at, or the defendant was kicking at the neighbor's door, was there another incident with the neighbor?
There was. That is when he punched through his apartment wall into the neighbor's apartment.
Okay. Yeah, can you please describe to court what Plaintiff's Exhibit 2 is?
First page is the actual lease violation on November 9th for him kicking his neighbor's door repetitively at 2:30 a.m. So that was November 9th was the door kicking, and then a week later was the door or the wall incident.
What is it that exhibit? It's a report? Is that what that is? What is it? No, just tell me what it is.
Oh, I'm sorry. This is the lease violation of when he was kicking the door in.
Okay, so that's something that your office drafted? Or
this is something that, yes, this was a lease violation
Okay.
that the office drafted.
Okay, and this was something that would have been provided to Mr. Blocker?
Yes, ma'am.
Okay, and how would it have been provided to him?
Mail and delivery on the floor.
Okay, thank you. Any objection to that
I
exhibit?
never got this.
You're objecting that you never received
I
it?
never received that.
Okay, so again, that's a dispute. What you're saying, all the things you're telling me are okay for you to share. They're just not objections under the evidentiary rules. What you're saying is you dispute it, and I'm going to give you an opportunity to tell me your side at some point. So you save up all of those disputes so that you can make sure you address them then. But when I'm asking you if you object, what you're going to have to tell me is no objection, for example, that's not relevant evidence, or objection, that's hearsay. Those are the things that I'm asking you right now. That does not sound like you have an objection, so plaintiff's 2 is admitted. Mr. Blocker, you can question the witness if you'd like.
Did Mr. Blocker, when Mr. Blocker first moved into the apartment, did you guys send him 3 months of mail saying that he hadn't paid his rent, violating the statements that I sat up there and paid my rent? For 3 months, did you not send me notice saying that I hadn't paid rent?
I was not managing the property when you moved in.
So this is why I need a continuance, so I can prove my point. You guys are gonna sit up here and have me with no evidence, sit back and combat this stuff that they're sending.
How is that relevant?
How's it relevant?
How is that relevant to this issue? The issue that they are bringing you to court for is for termination of tenancy, not for non-payment of rent. And
Because I'm showing where they sat back and violated the lease in the first place, because I sat back and paid the rent, was up on day rent, and they sat back and violated, sending me letters stating that I hadn't paid rent. Then I could sit back and go from like I asked you to sit back and have the camera work prove that I was there the day of the wall incident, begging them to do something to to the next door neighbor. I can also sit back and go and get my police reports to show that I sat back and I've had police reports that stated they were supposed to get
Hey, the courtroom gets technical. The judge painstakingly explains the constitutional rights being waived and the consequences of pleading guilty, including potential deportation. Viewers witness the precision and patience required in law, while the defendant's attempts to grasp the details inject tension and drama, emphasizing the weight of legal knowledge in critical moments.
Why they're evicting you is for these 30-something plus violations for conditions of your pet, for kicking in walls or punching in walls, and for kicking in a door.
Well, that's what I was sitting up here trying to state, because I did have permission from the first landlord to have my pets. I sat up there.
I don't think that there's a dispute I don't think the dispute, at least what I'm reading in these exhibits, is not that you didn't have permission. It was leaving it unleashed in the hallway or in the common areas, or pet waste was the issue.
And like I said, all 30 of those issues are not valid.
Okay, well then you'll get an opportunity to address that when you give your testimony, but you're not gonna get this witness to tell you otherwise. Do you have any questions for this witness?
No, I don't know.
Okay, any more redirection for this witness?
No, Your Honor.
Okay, ma'am, you can have a seat. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, it is.
You can have a seat, sir. You were here when I indicated the rules about how your responses are to be. They should be verbal, loud, and clear. And then if there's an objection, you will hold your response so that I can make a ruling on that objection and then tell you if you can give that answer or not. But first, can you state your first and last name and spell both of them?
Jeffrey Mills, JEFFREY MILLS.
Thank you, Judge. Mr. Mills, can you please state your occupation?
The maintenance at South Washington property.
Yeah. Are you familiar with the defendant?
Yes.
Could you please describe for how you're familiar with the defendant?
Well, he wrote me a dirty letter saying I've been inside his apartment and I wouldn't take 2 steps in that apartment, you know.
Have you had any, other than the letter that was written, have you had any other conversations with the defendant?
That's about it. The letter and him going crazy in the hallways. That's about it.
Have you seen him do anything in the hallways?
This is dogs running loose all over the place.
Okay. So you've seen his dogs running
loose, crapping all over the place in the yard. And
I want to show you Exhibit 1, packet on the second page. Could turn to page 2. Like previous testimony said that defendant wrote a nasty letter. Is that, can you review second page of Exhibit 1?
Yeah, is it the letter? Yeah.
Is that the letter you're referring to?
Well, yeah, I haven't seen it in a while, but yep, this is it.
Have you had any other interactions with the defendant other than that letter and the dogs?
Yeah, that's it.
Okay. I have no further questions, Mr. Mayor.
You have any questions for him?
Yes, when did you see my dogs use the bathroom in the house? Because you've never been outside to see my dogs use it. When did you see my dogs? Or was it camera?
The cameras.
Oh.
And I also see you walking around. Yeah. It's no secret.
Any other questions for him?
No.
How many dogs have you seen, sir?
3.
3 dogs? You mentioned on response to one of your answers that you wouldn't take 2 steps inside of the unit. Why is that?
Well, this place is
As questions about IDIP programs, community service, and blood alcohol measurements arise, the tension ratchets up. The judge calmly dismantles misunderstandings, clarifying the science, legal precedent, and potential consequences. This part captures a teachable moment for viewers. Courtroom confusion can lead to worse outcomes, and clarity from the bench is essential.
No, Judge.
May this witness be excused from the stand?
Yes, Judge. Yes,
Thank you,
Judge.
Mr. Mills. Any other witnesses?
No, Judge.
Okay, are you gonna call any witnesses?
No, ma'am.
Do you want to give testimony yourself?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. Okay, you can proceed with your side.
Okay, so now the fact that I sat back and asked for literally camera work to prove that my apartment had been violated, broke in, just like my 3 dogs were took out without my permission to be taken out, that shows that. the
When was your
apartment-
dog taken out?
My dog was taken out the night of the stated, wall incident by animal control, and I never gave consent.
Okay, so you're saying animal control came and took custody of your animals, and this was in November?
November, yep.
Okay, and this was the night of the what incident?
This was the night of the stated wall incident, I guess.
Okay, okay, so you did kick the wall in
No,
or
I
punch
did
the
not
wall
kick
in?
the no, I did not state that. I'm stating that this was the sitting up, this is when my dogs were took out, when I got took out of my apartment illegally. That's what I'm stating.
You got taken out of your apartment?
I got taken
By
out
whom?
by the police, Atlantic.
Oh, you were arrested, sir. Is that what you're saying?
No, I was not arrested. I was took out of my apartment because a crime hadn't been proven committed.
Oh.
So
I didn't say you were convicted. That's when a crime is proven. Arrested is you're taken into lawful custody of the police department pending a conviction. So you were arrested by the police and removed from the property?
I was sitting up, like I said, took out of my apartment.
Okay, the police came to your property?
The police who came to my property, yep.
Did they put handcuffs around you?
Yes, they did.
And they removed you from the property?
Yes, they did.
And that was in November?
That was whenever, November, yep.
Okay. And then animal control came that same day?
The night I had to have the judge from 30th Circuit to tell me that they came the night. They never
Okay,
asked.
so you weren't there when animal control came, so you don't know who took the animals?
That's who got my dogs in their custody.
Oh,
The judge from 30th
that's
Circuit.
hearsay then, wouldn't it be, for you to tell me what you heard?
That's what.
You just objected to someone else's hearsay. So I'm asking you what your personal knowledge is. You don't know what happened with the dogs then. Is that correct?
That's why I would need camera work that you're denying me from.
I didn't deny, I don't have control over your camera work. I didn't deny you anything.
I sat up there and asked for a continuance so I could get the camera work.
You
that I was in
had, you
jail.
had over 30 days to seek that
I've been in
information.
jail for the whole 30 days.
Okay, you can make a request for evidence from jail.
I've made a request.
The same way you can file motions from jail.
And I did file motions, and I sat up there and filed the motion when the Congress gives you the authority to have me in here. None of my motions have been answered.
I don't have you in there, and I don't know what you're talking about when the Congress has give us the authority to get you in there. I don't know what you're pending, what you're in court for. It's not on this matter. It has nothing to do with this matter. You're here today for an eviction.
I'm here today.
The defendant wants a lab analyst and a jury trial over the exact decimal of blood alcohol content. The suspense peaks here. The audience sees the judge expertly manage both the defendant's demands and the limits of the law. The tension is tangible. A misstep could drastically increase penalties. This segment showcases judicial patience versus legal ignorance in full force.